Good morning. I hope you did well, and that New York City with its snares did not snare you too badly. I know snare is a strange word for the delights of New York City, but there are also some pitfalls, so gotta be careful. You can't hear me. Okay, I thought I had my, this is a problem, and I think the justice has already told. Hello? No? Okay, it was in my shirt jacket. Okay, Steve Swirsky is our session moderator. Steve is an extremely able lawyer whom I've known for a long time. He's a member of our advisory board of the Center for Labor and Employment Law, a very, very able fellow and leader in the field. And I'm glad he's on the board, and it's your job to introduce the panel and moderate it, if you want to sit here. I used to be a fifth wheel, and now I'm a fifth panelist. Okay.
Better than a fifth columnist.
It is, you're right.
Yeah. So thank you, Sam. Great to be here. Thank you, everybody. My name is, as Sam said, Steve Swirsky. I'm a partner at Epstein Becker Green and a labor lawyer of the old school type. The first panel this morning, the focus really is AI developments in the U.S. workplace, U.S. and EU structures. It's a very good panel with real depth of expertise across the field. Erin Cannell from ORIC, who's the co-chair of ORIC's EEO and OFCCP Compliance Group and Pay Equity Task Force, a real trial lawyer, takes cases to verdict. One of her real focuses in her practice, which is probably why she's here this morning, is the use of AI in employment decision making, which I think is something we're all going to continue to have to learn about and face more of. Next speaker is Professor Julius Stanojevic, I hope I said that right, who is a professor at the NYU Tandon School of Engineering and the Center for Data Science and the Center for Responsible AI. She's an associate professor in the Department of Computer Science and Engineering. Nice to have somebody who's not a lawyer speaking to us. They probably can tell us more about the real science and the real art. She's a member of New York City's Automated Decision Systems Task Force, and her research focuses on responsible data management and analysis, which is key to the use of AI. The other panelist slash commentator is Adam Klein, who's the managing partner at Outten Golden. He leads and he founded the class action practice. He is a longtime practitioner in this area, focusing on class action work. We've worked together over the years. We've been on other panels. I think it's going to be a really interesting presentation.
Good. Who starts?
All right, I'm going to get us started. Can you all hear me? Okay, so I am going to start us off by talking about the EU AI Act. This act is very timely. The most recent version of it came out this week, and it is a very big deal. Even though it is an EU act, it absolutely is going to have impact here in the US, not only because it has, the act itself reaches activity in the US, but it is widely regarded as a blueprint for further AI regulation. And we're already seeing that here in the States. This morning, just reading the news, there were all kinds of articles about a new law in Colorado that regulates AI that is clearly based on this new EU act. So I'll start just by giving a basic overview of it. I call this the elevator pitch because the act itself is quite long. It's 400 pages. But it really is the first piece of legislation that comprehensively regulates AI, more than just in the employment space, but that includes in the employment space. And so the act itself really covers two types of AI systems and general purpose AI models. And the objective is to ensure that AI products that are placed into the European market are safe and respectful of fundamental rights. The Act takes a risk-based approach to AI systems And general purpose AI models are regulated regardless of risk. So the first thing that it regulates is AI systems. The definition is here on the slide. And when we think about AI systems, these really are the types of things that you see in employment decision making. So they are a machine-based system that is designed to operate with varying levels of autonomy, that exhibit adaptiveness after deployment. So, you hear about algorithms learning as they go, so they adapt as they go, and that for explicit or implicit objective infers from the input that it receives. And if you read the details of the act, it's this concept of inferring that is really key to these AI systems. And these are some examples of different types of AI systems. And again, if you think about their use in employment, so using any type of AI tool that makes predictions, that can make predictions about performance, that can make predictions about who's going to be best on the job. You hear about tools that are used to rank candidates who have applied for open jobs. All of those would be types of AI systems. And when it comes to employment, AI systems in employment are deemed to be high risk. So the way the act is structured is that there are different types of AI systems, and anything in employment, anything in healthcare is deemed to be high risk. And that means that it is going to be subject to a number of pre-market obligations. The obligations are primarily with regard to the developers of these types of tools, but there are also obligations that apply with regard to deployers of the tools. So in the employment context, deployers would be employers. So employers who use these types of tools also have obligations under this new act. I will also say that even though the act was published this week, and becomes effective in mid-June, most of the obligations don't go into effect for the next couple of years. So there is a time to come into compliance with these laws, but it is getting a lot of attention now because it is such a groundbreaking act. The other type of AI product that is covered by the new EU law is general purpose AI models. And when we think about this, the general purpose AI models are any AI model that displays significant generality and is capable of competently performing a wide range of distinct tasks, and that can be integrated into a variety of downstream systems or applications. So when we think about this, these are going to be like GPT or large language models, those types of AI models that are not necessarily, they're not systems themselves. They would need to be adapted into systems. But any of these types of AI models are also regulated and covered by this new law in the EU. And these are just some examples of some GPAIMs, as the Act refers to them.
Just a point of information, does it matter how they're used?
It does matter how they are used. They need to be used like on the market in a commercial way. If they're just used until they are out on the market, they are not covered by the new regulations.
They have to be used to predict outcomes or predict employee behavior?
They do no. These are not limited. This
Not limited.
It's not limited to employment in any way. Adam, do you want to?
Well, I was just going to just ask a question or just follow up on that. I don't know if this is, well, I'll speak loudly. So, a lot of these technologies are basically embedded into
Yeah.
other systems. The term infused AI is sort of becoming, more frequently used. And so, just curious, how do you advise clients to think about, or how you would detect the use of systems that are regulated by the EU Act? Like, how would you know that it's embedded in another system?
Well, those are some of the things that you need to be taking a look at right now, absolutely. Again, as I mentioned, there's a long runway, and we do have a slide on timing. But if you are using any type of AI system or any type of AI product, and it's being used in the EU, you would want to be taking a look at that. But again, as I mentioned, Colorado just passed a law here in the States, and it is widely expected that these types of laws are going to be replicated. So part of the reason that we're focusing on this EU Act is because just the framework of it and the structure and the language and the definitions are already being replicated, and we certainly anticipate that that's a trend that's going to continue. So in terms of who is covered, the Act imposes different obligations for deployers. So again, that would be users of these types of tools, providers of these types of tools, importers, manufacturers, and the Act also provides definitions of what these different concepts mean. So as I mentioned, we do have a runway before this Act takes effect, but again, it is regarded as a blueprint for how AI regulations here in the States are likely to follow. And even though it is, again, broader than employment, it certainly covers AI used in employment. And in that way, it differs. We're going to talk a little bit about the laws in the U.S. The laws in the U.S. so far very much, when it comes to AI and when we see in litigation, are focused on employment, whereas the EU Act and similarly the new law in Colorado are much broader than just employment, AI used in employment. So we want to pivot now and talk a little bit about AI in employment here in the U.S., and I'm going to turn it over to Adam to lead that discussion.
All right, terrific, thanks. So just as a framing convention, I've spoken on this topic, I guess all of us have, over the years, and one of the questions that the esteemed Professor Estrecker asks on a regular basis is anyone deploying AI technology in the workplace, particularly in terms of employment practices?
The question I ask Adam is it being used to evaluate existing employees? That's the question I ask.
Okay, that's the more specific use case. So I think the more general point that I wanted to raise is that the use of AI or these sort of technologies more generally, and the terminology gets confusing, but in general terms, autonomous, Gen AI or machine learning or technologies that are used to assist or to predict outcomes, in general terms, is now ubiquitous in our ecosystem, not just the workplace, but everywhere. And I think of it as sort of like the adaptive cruise control in your car. No one thinks of cruise control as a separate technology. It's just in your car. There are lots of things in your car that do things that you wouldn't consider a separate technology or something that the car manufacturer will offer to you as a separate add-on. So you don't think of the left turn blinker as a technology. It's just part of the car. And I think in very general terms, that's essentially what's happening now. That AI, in general terms, is essentially infiltrating or infusing into our existence in every respect possible. And it's not recognized as a separate technology, or it's essentially a feature or built in or baked into existing systems. So that's kind of the framing convention. And I think it's important to understand that while we started this discussion years ago, thinking about it from a hiring selection process, so resume scrapers, or hiring selection devices that assist large employers generally who have millions of resumes. What do you do with all that stuff? Isn't there a better way to do this? That was sort of the use case when we started this conversation now years ago. And it's sort of gone full circle to, that may be an application, but it's actually everywhere. And so I think the general idea here is, so this is an analysis from SHRM, Society of Human Resource Management, State of the Workplace research studies. This is from about 6 months ago now, I guess. So 25% of HR departments use AI, and I think that's probably a very significant undercount. In actual fact, I think it's 100%, and it's probably been 100% for a long time. And it sort of points to the issue, which is that it's not being recognized. The earlier comment about, how would you identify the use of AI technology in other aspects of the workplace, even your phone, for example, uses AI. So we all have AI. It's 100%. It's been 100% for a long time, but no one sort of thought of it in those terms. It's the left blinker on your car. We just don't recognize it as such. So I'm just making the more general point that this technology is here. It's been here. It just hasn't been identified or labeled as sort of an independent thing separate from the actual technologies that you're using in the hardware, software.
Do you think it's gonna, do you think we will get to a point where there'll be a requirement that it be disclosed, almost like a warning on a consumer product, you know, that manufacturers will have to disclose that there is AI and what functions are done by it?
I don't think so. I don't think that's practicable. Or if it is, it's everywhere all the time is the answer. And so I could just give you a disclosure right now that it's everywhere all the time, and you're encountering it probably every 10 seconds.
And I'll just also chime in that going back to the way that the EU Act is structured, I think that that is going to be the blueprint, because there are very different requirements for the people who make the AI, the people who sell the AI, the people who use the AI, and it's just because it's everywhere, and so there's different obligations for those different players.
Thank you.
So, thanks. So this is kind of an illustration of the many different use cases. I will say too, you know, one of the implications, and it's, you know, here we are at NYU Law School, and you know, I presume some of the people in the audience are law students here. You know, there's, I would say, a growing disconnect between the skills required to practice law and what's being taught, or what the skill set of students coming out of law school are and what law firms need.
That's a big question.
Okay,
Are we
Professor.
teaching these people what they need to
Right,
practice law?
there's a growing disconnect.
Not just on AI, by the way.
Well, I would say with AI in particular, or more generally technology. So I've been saying for many years that law schools should teach computer science, in particular coding, and you know, to understand, just to, as a sort of, I run a law firm, so just to say it from that perspective, I would say this is transformational technology in terms of the actual use case in the workplace. And just to say that, because being at a law school, it feels awkward not to just point that out. Moving on, yeah.
Sorry, can I just chime in very quickly about, you know, who should teach what?
Sure.
So I'm a computer scientist, and we also don't teach computer science graduates what they need to know to do the work, because we don't teach them about the social implications. But that doesn't mean that we need to now teach computer scientists how to practice law, right? I don't think we need to be teaching lawyers how to code. It's a more general kind of a literacy and awareness skill set.
I agree to a certain degree, because I will say, litigating these issues, the learning curve is really high trying to understand the technology. So I don't know that you need to know how to code necessarily, but just understanding the science is a very steep learning curve.
Yeah, literacy is important, but also we need to work together, I think, is the main point.
Yeah, and it's interesting, just on that point, I mean, you know, my day job as a litigator, I work with computer scientists, computer science ethicists, which is an interesting group, and mathematicians. So that, just to give you a sense of the people that I personally interact with as a practicing lawyer, those are the folks that I work with on a regular basis. So if that's not something you've been exposed to, particularly as a law student, you just consider that and think about, you know, is that a skill or competency that you could be exposed to here or in your professional career going forward. Okay, moving on. That's off my soapbox. So SHRM again basically is sort of pointing out that there's a sort of a deficit between the understanding of how AI tools are being deployed in the workplace and what employers are doing to understand their obligations under the EU Act, or more generally in the US under various, well, mainly state law, but also federal law. And so there's, I would say, a disconnect between the use and application or deployment of these AI technologies and what employers understand their obligations to be and how these systems actually work in practice. So that's a real problem. And a lot of it, and I'm curious, Aaron, if you have a point of view on this, a lot of it is coming from the vendors themselves. So the vendors, there's a lot of marketing around, how valuable, particularly around hiring selection, performance assessment, and sentiment analysis, how useful those are in the workplace, without a lot of detail on how they work and what possible concerns there may be from somebody practicing in our field.
Yeah, I think that's absolutely right. I think there's a lot of attention on it. I mean, I think when these tools first exploded onto the marketplace, the idea was that they were more efficient and that they reduce bias. But now there's so much concern about algorithmic bias. And so there is a lot more focus on which is it and on trying to understand how the tools actually work.
Yeah, I would say too that, one of the sort of challenges is that, if you think of it, you go back in time and think about, hiring selection or some of the employment practices that have been traditionally evaluated under Title VII, under OFCCP guidelines. We generally use IO psychology and think of it from disparate impact analysis or based on discrimination under the Title VII framing. And generally there, the idea or the classical model is you look at the job competencies and then you try to find people who can meet those skill sets or competencies and you measure for that. That's the standard model, if you like. And with AI, particularly around hiring selection, it's really not how these systems work. So they're not looking at a competency model, they're looking at the skills of the job and trying to find people that can meet those skill sets. It's essentially a completely different model. And there's a lack of transparency and a lack of understanding on how the systems actually are deployed. They have advantages and disadvantages. They always have an answer. It's sort of fascinating. And they'll give you basically a set of people that the system believes the employer should hire. Why? The why part is opaque. So there is no why. We don't know why. We just have an answer. So that's a little alarming or dystopic, unsettling, but it is commonly used.
So is it the same in terms of what the system says about the people you shouldn't hire for the job? Is there any reasoning provided on the other side?
It's not susceptible to analysis.
Yeah. So I mean, it's kind of a black box then if you're going to litigate it.
It is a literal black box.
Yeah.
In fact, there's something called the hidden layer, and Julie can speak to that, but essentially the technology itself, the way it's been described to me is that it's not susceptible to human logical analysis. It does not work like the human brain, and our instinct is to try to understand it from our framework or understanding of how the world works, and it's a different construct entirely. And so it's a little hard to get your mind around, well, what does that mean? And I think the vendors, there's a lack of transparency in this area. Whether it's good or bad is a value judgment. Whether it improves disparate impacts or decreases bias or creates other problems, I think is unclear at the moment, at least from my view. I think there's some challenges. Erin is defending a case right now. We'll talk about it. But what the implications are profound, but they're also hard to understand at the moment.
Adam, can I cut in? I've asked you this before. Do we have any information? I've run a couple of conferences with HR executives. That's why I think this answer is still unclear. But do we have any information on how employers are actually using AI? So if they're getting in 100,000 applications over the transom and they're using it to help filter out some of those, that could be an aid. I have a good friend of mine, a co-author, Zev Eigen, who thinks it does a better job in subjective evaluations. I don't know. I don't think you should rely on a machine personally. On the other hand, maybe it's good to have a supplementary aid to relying on which college the person went to, which law school the person went to, the LSAT score or whatever. If it's used that way, there are problems with that, but it's not the same, it seems to me, as automatically deflecting to a machine's judgment. I'd like to know if employers are doing that, even at the hiring selection stage, and whether they're using it for, maybe you can't answer that, does the SHRM survey answer that? Because I have found, directly asking this question in HR executive meetings that I've run, I can't get a clear answer to that. Now, I know the vendors are selling the possibility of 1 million capabilities, I understand that. That's what we do that too, Erin, and I'm pitching a client, we're gonna make the world turn differently for them. The agriculture is going to be flowing in. The weather's always going to be great. You just have to use Auric Harrington. Everyone knows that.
Well, I mean, to give the lawyer answer, I think it depends. And not all vendors are the same, I would say too, and not all tools are the same. The good vendors will tell employers that you should not just hand things over to the machine, that there should be human oversight, and that just to take the tool that you gave an example of where they help sort all of the resumes that come in. The way a lot of these tools work is that they take the job posting at face value, and all they're doing is engaging in, and they're also taking the resume at face value, and they're just using AI to match the skills that are on the job posting and on the resumes and rank them. So to go back to when you're talking about competencies, well, it's not getting behind. If the job posting's wrong, then the sorting's wrong. So, it sort of depends on how the tools are used. But I personally always advise my clients, don't just hand it over to the machine. This can be a tool that can help you in your selection and in your decision making, but you should not just hand it over to the algorithm.
Can it be programmed to weight the various requirements in the position and to weight the various skills in the resume?
A lot of the tools are configurable, yes.
Yeah, I think, though, it's important to understand that there are sort of good use cases and bad use cases, and I would call them simple and more complex analytics systems or predictive analytics tools that are deployed. So I would say the good or simple use case is what Erin just described. I would say the more complex and bad use case would be psychometrics or gamified psychometrics or psychological assessments using public sourced scraped data. So some of these systems will go and find information about you or the applicant based on your interactions with the world and essentially quantify that and come up with essentially what's called a vector representation, not to get too deep in the weeds, but essentially a composite score or representation of applicants based on an entire array of information that then gets interacted. Anyway, that's very different than what Erin just described, right? So it goes from something that you can understand to something that you clearly, including myself, don't understand, and frankly, no one understands. And even the people applying it don't understand it. So that's a challenge.
Even the vendors don't understand what they're doing, and this is why they're resistant to transparency. I'll talk about this quite a bit, actually.
Yeah. So here in the U.S., I mean, we do not have anything that is nearly as comprehensive nor mandatory like in the EU. At the federal level, the federal government clearly is focused on this. We see a lot of, the White House has released a Bill of Rights. We see lots of guidance coming out of the federal agencies. To sum up, from my perspective, sort of the general takeaways from the federal government are that they're very focused on AI. It's a priority, as it should be. They're working together. We hear, if you listened to EEOC Chair Burrows yesterday, she talked about collaboration among the agencies, a whole of government approach. But thus far, they're really doubling down on the existing laws. Title VII, Adam mentioned UGESP, the Uniform Guidelines on Employee Selection Procedures, the ADA, the ADEA, but we don't yet have any type of new laws at the federal level that are really focused on AI, whether in the employment space or not. My view is that where we're really going to see the action is in the states. I already mentioned Colorado, but there are bills making their way through the legislatures in California, here in New York State. New York City already did enact one law, and I think that trend is going to continue, which is really not surprising. We see that with other developing areas of the law, including pay equity, pay transparency, and I think that's going to be the case with AI as well.
If I could just comment on that quickly, I think that's right. And I think one of the problems here, and I think this panel is an illustration of it, which is that there's a lack of, I would say, technical proficiency within the law firm or a lawyer space, professional law space, and that's going to be challenging to overcome. I mean, you'll hear from Julia, it's an entirely different ecosystem in every respect possible, including the vocabulary. And so there's a need to kind of build that competency up, and there are some efforts around it. The other thing is Title VII, or the federal statutes more generally, aren't really designed or tailored to address these kinds of emerging technologies in terms of their application, and we'll get to it. But essentially, if you think about it, if you're subjected to or exposed to an AI system as an applicant, for example, you have almost no information about what that interaction actually was, what happened, what was assessed in terms of your resume, your social media postings. Was there a psychometric assessment? there's just literally no information about what the selection tool was and what happened as a consequence of its application. So it makes it almost impossible to understand, the implications from a federal civil rights enforcement perspective, including the government. They have the same problem. So the lack of any transparency at all makes it near impossible for the enforcement agencies to effectively challenge it under existing law, at least under the federal statutes.
So where is the burden going to be in litigation challenging the use? Is it going to be on the party that's making the decision and not accepting somebody, or is it going to be on the person who says, I was screened out inappropriately, there may have been less discriminatory or less exclusionary tools that could have been used?
It's a very hard question to answer in the abstract. I think it really depends on the technology. It depends on what information is available to assess whether a violation occurred. The standard for federal law in terms of standing is Iqbal Twombly. Basically, that you have to allege facts which would provide that there's a plausible violation of the statute. And so essentially, there's the fundamental is what is the evidence on causality between your protected characteristic and the outcome that you're challenging? What is the evidence of a causal relationship? And that's really not known to the applicant or other than the vendor and the employer.
And if you think about it from a Daubert perspective, I mean, have the courts started opining on the science itself as being an accepted science, and that I don't know if defer is the wrong word, but accept it as such?
I don't think the litigation has gotten there yet. To echo Adam's point about Iqbal Twombly, most of the litigation is still being litigated at the pleading stage.
Yeah.
So we're not seeing a whole lot even getting into the AI. The key issues that are being litigated now is who's responsible. Like Adam said, has the plaintiff pled enough to prove causation, those sorts of issues. So, but I think, we're on the brink of getting into those types of debates. Yeah.
So if I may just chime in here, as a preview of what I'm going to say, I'm hearing a lot of wishful thinking here. You're attributing a lot, and I mean this seriously, you're attributing a lot of sophistication to these tools. And in most cases, it absolutely is impossible to assume that these tools even work or that anybody understands what they do. They're just looking for correlations, patterns. Very often they're just random coin flips, right? So you should be very, very skeptical and assume that the tools don't work unless somebody showed you that they do concretely. We're getting too much into the weeds of, I think.
All right, well, we'll keep going because we want to make sure
Yeah.
that Julia has enough time. So these are just some examples. We've already touched on the way that AI is being used in employment. And as I mentioned, this is something that the EEOC is very focused on. Adam, do you want to talk a little bit about the NIST?
Right. So President Biden issued an executive order requiring the federal government agencies to address AI and risk management, similar to the EU, but sort of in a different way, which is, I would say, less directed by statute or act. And so the Office of Science and Technology Policy at the White House has been directing this work now for a while. And so NIST it was tasked with coming up with an AI risk management framework. This is not just specific to the workplace. It's essentially a federal government standard that NIST is creating. And NIST does this kind of work. That's their technical proficiency, is to create technical standards. And so they've come out with a risk management framework. It's similar to the EU Act in terms of sort of characterizing or classifying risk type and then mitigation efforts. And I would say, similar to, if you're familiar with SIOP principles, Society of Industrial Organizational Psychology, so the SIOP has a set of professional standards, and this is similar to that kind of approach.
I'm sorry, I didn't hear. What's the name of the organization?
SIOP, Society of Industrial Organizational Psychologists.
They're the ones that...
No, so SIOP is the technical experts in the workplace.
Right.
NIST is the government agency tasked with coming up with AI.
NHST?
NIST.
NIST.
Part of the Commerce Department. NIST, if you know anything about the federal government hierarchy, NIST is essentially the technical experts in our U.S. government.
Okay.
They do a lot of work around technical standards across the entire ecosystem in the United
And
States.
they've published standards.
They have, yes.
Thank you.
All right, so we're going to pivot. We touched on litigation, but we're going to turn to litigation. We are starting to see cases filed that involve allegations about discriminatory AI. As I mentioned, most of them are still at their early stages, but this certainly is a trend that we expect to continue. Adam, do you want to talk a little bit about what you were saying on causation and
Yeah.
Iqbal Twombly?
Right. Well, it's a real problem for the plaintiffs, and I've been asked several times, why haven't you filed any of these cases? It would, I think that would be fun and interesting work, but the problem is the client walks in your office and says, "I was denied a job." I say, "Well, why is that?" "Well, I don't know." "Did you apply to a technology?" "Yes, I did." "Well, what happened?" I pushed buttons and I didn't get a job." So, okay, that's kind of a challenge. I'm being a little dramatic. Maybe there's a little bit more to it. But in general terms, the lack of transparency or information asymmetry is so severe that under the standard, Iqbal Twombly standard, which applies to any federal court action, there's a minimal requirement that you allege facts, which I mentioned, that would support causality. So you have cause and effect based on immutable characteristic, so that you can state a claim under a federal civil rights statute. Interestingly, we've litigated this issue in a completely different context, a case called Mandela v. NTT Data. Believe it or not, the case has gone up and down to the circuit 4 times, where issue has not been joined. It's 5 years later, believe it or not. And this is a case involving the challenge of the use of criminal history records for employment suitability. And the case was thrown out on Iqbal Twombly grounds because we didn't assert that in this context, for applicants working at NTT Data, that racial disparities in the use of criminal history records for hiring selection would persist for people with higher level education. Anyway, so long story short, we cited a academic study that was submitted as an amicus, and that got us over the hurdle to demonstrate that we have a plausible claim. Whatever you think of that, that's a lot easier than what we're talking about here, and that went up and down 4 times to the Second Circuit. There were a couple other issues here. So data quagmire, it's my personal favorite conversation when you talk about, if you get past Iqbal Twombly, God help the management lawyers. It is a freaking nightmare. Who owns the data? What would you do to export it? Is it preserved? Could the management, could the defense side lawyers actually themselves analyze it and make sense of it? I'm asking questions, I don't know the answers. I think those are really challenging problems because oftentimes the vendors have the data. They may not be in business, a lot of go in and out. They may not capture, they may not segregate data to each unique employer, so it may be commingled. There's something called ephemeral data, which may not be captured, so the actual selection outcomes, that data may not be preserved as a general matter. There are lots of things like that that are extremely challenging if the case was actually going to be prosecuted and defended in discovery. And a lot of cases are won and lost in discovery. I mean, that's just, and that's kind of what happens. The litigation hold, how do you do that? What does that mean in this context? And then the last point is, and then we'll get to it, which is sort of a competency level. It's a theme, I think, of this presentation this morning, which is that, if you're in this area, if you're interested in this issue, there is a real need to understand how the technology works enough so that you could be fluent and conversant and explain it to a judge and jury. The jury part is the most challenging. And so that's a major challenge.
So we did provide materials that accompany this presentation, and some of the materials are from the Mobley versus Workday case. It is in active litigation. if you're interested, I would recommend that you take a look at the materials. What's interesting here is that this case is still at the pleading stage. It's now on its second motion to dismiss. And the pleading motions involve some of the issues that Adam talked about around causation, but one of the key issues here is that the plaintiff alleges that Workday's AI-powered software is discriminatory, and the allegations are that it discriminates on the basis of age, race, and disability status, but he does not allege that he applied to work for Workday. He alleges that he applied to work at a number of employers who use Workday's software. So the issue at this stage, or one of the issues at this stage of the case, is can Workday be liable as the software vendor for employment discrimination claims under Title VII, the ADA, and the ADEA. The EEOC did file an amicus brief in this case, and it is in the materials. The judge has not yet issued a ruling. The hearing on the motion to dismiss was last week. So again, if you're interested in this area, take a look at the materials.
Which court is it, Aaron?
It is the Northern District of California.
Thank you.
And then lastly, we just wanted to touch on some attorney ethical obligations. There's going to be a whole nother panel on this, but there's really sort of two concepts that we were discussing in preparing for this. We've touched on them. One, and I think this is what the panel after us is going to address, are the ethical issues that arise when attorneys use AI in their practice. And I'm sure you've all heard about the attorneys where the AI tool generated cases that don't exist. And there's horror stories like that. But I will say it is being used in the practice, and so I think there's a lot of ethical issues that arise around that. But the other, I think, ethical issue to think about is the one that Adam flagged, and that is litigating these cases, making sure that you, to the best of your ability, understand the technology, and in a lot of cases are working closely with experts to help explain the technology, which is a whole separate set of ethical challenges. And so with that, we want to turn it over to Julia.
Thank you. And the mouse is inactive. Maybe I could get some help. Thank you. Okay. So it was really wonderful to hear this conversation and chime in periodically. I spoke at one of these events a few years ago, and I was the odd one out. I feel like we were talking about technology, but I was the only technologist speaking. And this seems still to be the case, but you all are much more acutely aware of the fact that AI is everywhere, as Adam said, right? That it's impacting all of us, both personally and professionally. And so I'm a computer scientist and an engineer by training. My goal is always going to be not only to find what's wrong with technology or with its use, but also to help us construct a better future. And this better future, specifically as it pertains to hiring and employment, in my mind is about using AI to help us make better decisions, rather than to hide behind AI to make decisions that are unaccountable but on a large scale. And we spoke about bias and discrimination, of course. Another thing that I want to raise is that lots of these decisions are arbitrary. And there needs to be a conversation about whether we are comfortable trading bias for arbitrariness, right? And this is actually very often what's happening. And I'll speak about this a little bit more. So this is the website of my center, the Center for Responsible AI. Please take a look. We do a lot of socio-technical work as engineers. We do a lot of work in policy, specifically in AI governance, and also in the use of AI in hiring and employment. This has been the domain that I've been really interested in for many years. And we also do a lot of work on education and AI literacy and training of different types of individuals, such as the audience here. Because to me, the main issue that we're facing right now is not that we need necessarily more and better algorithms. We need more and better informed people who are able to control how these algorithms are used. So I'm going to kind of ground us a little bit in some useful, productive ways in which we have been using AI in society. And these are very simple examples that I hope you can all relate to. And I'm going to explain what I mean by responsible AI through these examples. Roomba, the smart vacuum, on the top left of the slide. It helps us clean our apartments, our houses. We know that it works because you leave it in the room, you come back, the room is clean. You can actually check that it works. We don't know how it works. It's literally a black box. I mean, it's a black kind of a round object here, right? We don't have to know how it works. We don't have to know how it's programmed. We have to know how to check what it does and whether what it does is what we want it to do, right? This is a super simple example. Let's keep that example in mind when we're thinking about more complex uses of AI, because ultimately it's all the same framing, right? What is it trying to help us with, this particular box? Can we check whether it's helping us reach this goal? And are we able to make that box, right? This is another thing. So it actually took many, many decades of research in AI, specifically in an area of AI called planning, traditional AI, to give us Roomba, the smart vacuum. It has failed many times, but this is one of the first successful examples of the use of AI. It wasn't easy to do this, but we are able to do this at this point. Why? Because we have the hardware, we have the software, we have the data, we have the algorithmic understanding of how to do this, right? So we have this technical readiness, as I'm calling it. And also chess playing AI and the smart lights, these are two other examples that fit into this category. A slightly more interesting example, people have been using AI to help clinicians diagnose different types of diseases, cancers in particular, from magnetic resonance imaging scans, MRI scans. And there are two projects here that I'd like to highlight. One of them is actually about generating data with the help of AI. Somebody goes into an MRI machine, they spend a lot less time inside that machine than they normally would, 10 times less time, I guess. And then this machine does a kind of a preliminary scan, and then it looks at historical data from other individuals, and it fills in the blanks. It extrapolates. And then this semi-synthetic MRI image, it's called a fast MRI, is presented to a clinician, and they can look at it and they can say, yes, this is good enough for me to come up with a diagnosis, or no, dear patient, please go back and get a traditional MRI, right? And this is really, if we are putting this technology into clinical use, when we put it into clinical use, this is going to be groundbreaking, because it will help a person who is claustrophobic be inside an MRI machine for less time. It will help us see more patients, right? It will expand access to MRI technology in areas where this technology is in short supply. So there's a clear need for improvement here. We are ready, or almost ready, to make these devices and put them into clinical use because of hardware, software, and data. We can check whether they work. There is a ground truth here. You can bring in a clinician, you can bring in 10 clinicians, they can look at an MRI, and they can determine whether or not the patient has the particular type of cancer that the MRI suggests, right? So there is an actual fact that you can either confirm or refute. And most importantly here, decision maker readiness. The clinician who is using that image to come up with a diagnosis, they understand that they cannot hide behind the machine told me so when the diagnosis is incorrect, right? They have studied medical ethics, they have some background in AI sufficiently to understand when to trust it and when to doubt it. And this is an integral component of responsible AI use that very often lacks in the use of AI in hiring and employment. For example, when HR uses an algorithm to help screen resumes, these people are not trained on how these machines work, how and whether to be skeptical, right? They just get the answer. There's always an answer that the machine gives. And the person is pressured, the HR person is pressured to hire faster, screen resumes faster. There's a high volume, right? So this decision maker readiness here, it lacks in the domain that we're talking about. So why do we want to use AI in hiring and employment? 3 reasons, maybe more, but I can think of 3. Efficiency for employers, hire quickly and find candidates who are good. Efficiency for job seekers, meaning you can apply with a click of a button. The machine will match you with all the promising positions, right, for which you may be a fit, and it's a much easier experience than before. And mitigation of bias and discrimination. This is another hope that we have for these machines, right? Because people are notoriously bad at hiring. We try to hire people who look like us, and this is sort of the definition of bias. And very often such practices are discriminatory. When we think about whether and how to use AI responsibly in a particular domain, for example, in hiring and employment, we need to take a stakeholder point of view, right? Because whether the use of AI is principled, responsible, etc., depends on who is impacted, essentially. You all know this. So what are the benefits of the use of this technology? To whom are these the benefits? What are the harms? Who suffers these harms? How do these harms arise? And who can mitigate them and how? So these are some of the questions that we should keep in mind when we're thinking about whether AI is being used properly. So now I'm going to give a couple of specific examples, and this was already actually discussed to some extent. So my colleagues and I, including a social scientist, a bunch of data scientists, an IO psychologist, we designed and conducted an audit of 2 commercial tools that claim to construct the personality profile of a job applicant based on their resume or their LinkedIn profile or their Twitter handle, their Twitter feed. So this sounds like a claim that's too good to be true, and it is too good to be true. It's actually not true. So the working title of this paper was Calling Bullshit on AI Personality Prediction and Hiring. But I wasn't able to assign that title because one of the co-authors is an investigative journalist, and she said, I will never be able to talk to anybody if I publish anything with this title. That's Hilke Schellman here at NYU. So anyway, the tools that we audited were Crystal knows, and Humantic AI. Humantic is a startup, Crystal is a much larger company. We got resumes of job seekers through an IRB-approved study. We got subscriptions to these tools. We paid them. They didn't know we were looking at them. And then we would feed the resumes through, and we would look at the output. The output is a personality score vector with either 4 or 5 numbers in it, depending on which personality framework they're using, DISC or the Big Five. And it would give you something like the applicant is 0.3 conscientious, 0.5 neurotic, and 0.7 dominant. Right? This is based on psychometric instruments. And then what we did was we changed things about the resumes that shouldn't matter at all if personality, in fact, is something that you can construct, and if these tools are constructing personality. So we would change the format of the file. The same resume in PDF versus in rich text. And the tool doesn't tell you which it prefers. It says, give me either. And for very many people, we saw very drastic changes in the personality scores being constructed. So dominance moving from low to high, for example, or low to medium. And it wasn't necessarily PDF that was better. Sometimes you were more dominant in PDF, sometimes you were less dominant in PDF, right? So this is a kind of a thing that we need to pay attention to. And unfortunately, current laws, like the New York Law 144, Local Law 144 of 21, it does not prevent these types of practices from happening. So the failure mode here is that decisions are arbitrary. Who benefits? The vendor benefits for a time because they make money, no matter what. Who is harmed? Everybody else. The decision maker. The unqualified candidates who are hired are going to be harmed in the long run. The qualified candidates who are not. The tool doesn't work is how the harms arise. And who can mitigate the harms? I mean, in this case, it's really a conversation between the employer and the vendor. If the employer cannot be convinced that the tool works better than a random guess, and I have here Karl Popper flipping coins. He's a philosopher of science who gave us this baseline that if the tool doesn't work better than a random guess, it doesn't work. It's much cheaper to flip coins than to buy the software, right? And so I think that to mitigate here, we should not be using these tools unless we actually know that they work. I'm going to wrap up in just a second. I think I'm running short on time, right? So the other example that is a classic is resume screening and bias in resume screening. You've all seen this. This is just one such case, gender bias in Amazon's screener. I want to bring it up to say that Amazon is a really powerful and well-resourced company. They failed to address the problem of gender bias in hiring with the help of a technical solution. And they have all the data in the world, all the smart programmers in the world. You just really cannot debias the world with the help of an algorithm like this. So I'll leave it at that. There are many other examples of this. Why are these examples discriminatory? Well, it's because there's bias in the data. The data reflects the world. The world is biased. Women are underrepresented in the workforce. If you require some standardized test scores, these test scores may be miscalibrated. They may work well for some demographics and less well for others. It's really hard to untangle this. So here again, in my mind, a random coin flip or a stratified sampler that is just going to say, I'm going to get people in proportion to whatever demographic group membership I want, would work better. Once you've filtered out everybody who has the qualifications that are stated in the job ad, just take a sample. So, based on these couple of examples and many others that I don't have time to discuss, I'm going to claim that AI rarely works in hiring specifically, because it does not have any of the hallmarks of responsible AI, except for the need to improvement, right? Nothing else we can see here. And if you think that chatbots are going to help us or that generative AI is going to help us, I want you to read about this recent scandal of New York City installing a chatbot to help small business owners understand what is legal and what is okay to do in the city. So one of the things that the chatbot recommended is that it's legal for an employer to fire a worker who complains about sexual harassment, doesn't disclose a pregnancy, or refuses to cut their dreadlocks. And everybody's favorite is this example of whether it's okay to serve cheese that a rat took a bite of, and the chatbot says yes. So again,
I think that,
yeah.
I would love to hear more of these
Yeah.
examples. I think that the rat and the cheese may be the perfect place to end this conversation.
Sounds good. Okay.
This was really enlightening. I'm going to
So
go
let me
back
just,
and tell my
show you
partners
this.
and clients, nobody knows.
Yeah.
Thank you so much.
Great, Pam.
All right, thank you.